I'm Howard Kline, and we are going to be talking about the use clause and the variances and issues that come up with it. This is most people, except professionals, treat this as a seemingly unimportant provision, but it so affects so many other things. So let me introduce first my panelists, my co-host, Peter Morris, and then Jerry Neitlich is over to the left of me. So why don't I start out and let me share our PowerPoint where you'll be able to see our smiling faces. And Peter, why don't we, and if you're interested, of course, you can see our short bios that I've done in the beginning of the PowerPoint. And why don't we start with the use clause negotiating perspective? And Jerry, why don't you start telling us what, when you negotiate for a tenant, what is it that you look to accomplish with the use clause?
Well, just as you see in the PowerPoint there, Howard, we want to make it as broad as possible for a lot of reasons, particularly as mentioned earlier in our conversation, that oftentimes a landlord wants to restrict to a particular type of use. But from the tenant standpoint, they want it as broad as possible. I mean, especially, let's take, for example, let's start with office, which is a great percentage of my practice. In an office, we're not talking about chemicals, we're not talking about a lot of other things, so it's a general office use. But the landlord likes to know what you're doing inside there. So typically the, if you want to call it the compromise that we have in a use clause, is something to the effect of, or any use as permitted by law. That's kind of the comma, blah, blah, blah. So this way, if you're an accounting firm and you want to get out of a lease eventually and you want to sublease it to a law firm, the landlord could say, hey, this is illegal. You could say this is a legal use. It's the same type of use and there's no issue with it. But if you restrict it to a law firm and the landlord and tenant are in some sort of a disagreement, the landlord could say, I'm sorry, you can't do that because it's not X firm, you know, et cetera. So that's typically the way we get around that, to be as broad as possible.
All right, well, now we will get into the discussion as to what's legal, you know, and where the landlord may often pull back on what's legal, et cetera. But Peter, why don't you talk about, you know, what is the landlord looking to do? And then we'll talk about it. Let's talk about just generally, and then we'll talk about perhaps specific instances, types of property.
Certainly. So generally speaking, what the landlord wants to do, as Jerry pointed out, the landlord does want to know what's going on inside the premises. That becomes more important in some asset classes than in others. But what it does is it gives a confine as to what's going to be happening inside the building. It has a lot of reasons for doing that. The landlord wants to know, for an example, that there's not going to be an illegal activity. The landlord wants to know if there's going to be insurance risks because of the type of tenancy that is there. The landlord wants to know the type of consumers or customers or visitors that could potentially come to the property as a result of that particular use. And as Jerry pointed out as well, and why he has that little workaround saying any legal use, landlord can use the use clause as a little bit of a stick if they need to, if there's a disagreement between the landlord and the tenant. So as a general comment, it's really just being transparent and knowing what's going on in your property, generally speaking. And as I mentioned, it does get a little bit more specific when we get into certain asset classes. We'll talk about that.
Well, I know, let me click on me here. I know that from my perspective, when I negotiate on behalf of the tenant, I do often agree to any legal use, but then I have to look at the rest of the lease to see what the landlord's trying to take back. But when I represent the landlord, I'm really looking for and we'll talk about the term of the lease, I'm looking for as much leverage as I can get for the landlord. If the lease is 5 or 10 years, that's a long time. And I really want the landlord to be in the best position possible going through the whole term of the lease. If the landlord chooses not to take advantage of their leverage, which is fine, but I want to make sure that they have that leverage, whether it be 2, 3 years down the road. Jerry, unless someone has a comment, I'd like to move on.
I just want to bring up one point which Peter made, where, yes, the landlord wants to know what's going on inside. There's a whole, I don't know if the word is movement in today's world, the WeWorks, the open space, those kind of premises. And a lot of them are people intensive, where, they have the open space, but it may not be cubes. It might be just long tables with computer screens and people facing across from each other. So you may end up with a 3,000 square foot space with 30 people in there. So now the landlord, when you're talking about the use, they want to know that this is how you're going to use it, because it could affect the parking, it could affect the utilities, it affects so many things. So Peter, you hit the nail on the head there. What's going on inside?
Yeah, and actually you raise a good point that maybe we'll talk about later, is the population density.
Mm-hmm.
And it does affect parking. It does affect fire codes.
Mm-hmm.
It affects egress and ingress into not only the building, but the particular space. So yeah, all of those things are important, that if you're talking about a communal type office space, you do have to pay attention to those things. I will note that the lease that I was working from for the basis of this had a provision. It was kind of vague, actually, but it said that the amount of people, something to the effect that the amount of people populating the space can't be more than the average amount of people occupying similar space in the building. And
monitor that, right?
Yeah, let's work the math out on that one. I don't know how you do that.
No. I mean, that's what it said. And this, as I said, this lease, it was a lease for a law firm, and it was with a big landlord in downtown LA, and they were going to flex their might. And honestly, I didn't even challenge that. And there was no reason for me to challenge that because for the most part, it didn't make any difference. It's like, yeah, try to prove that.
Exactly.
So I'm not going to argue it in the negotiation stage. So Jerry, why don't we talk about the length of term and how that might affect your negotiation of the use clause?
Well, I'm a proponent that, every word is important. And, again, like you're saying, does it depend on the length of term? An example I gave before we got on the air was you can have a 3-year lease, a 5-year lease, a 10-year lease, but certain occurrences may happen in the 1st year or in the 5th year or the 9th year. So if some landlords, you hear, oh, the longer the term, the more I'll give, the more flexibility I'll give. But on the other hand, a lot of my clients, I work with a lot of small businesses. They might be 3,000, 4,000 square feet or less. And my answer to the landlord, when you talk about length of term, we'll give you more. I say, well, this is their only 3,000 square feet. So it's probably more important to them. So when you talk about length of term, something can happen 3 months in. So if your use clause is, more, I'm trying to think, maybe Peter, you could chime in here. I'm thinking of an example where the length of term might impact the use clause. I'm a proponent, whether you have a 1-day lease or a 10-year lease, that use clause should still be the same.
Here's my perspective, and I look this in terms of the likelihood or not the likelihood. To me, the shorter the term, I'm less representing the landlord. I'm less likely to insist upon a very restrictive use clause, because while things could happen within a year or two, really where we run into the problems for the most part are the longer term leases. Anything longer than 3 years, all of a sudden the tenant wants to, 5 years into it, the tenants go, my business isn't working. I want to sell my business. There are all kinds of issues. So to me, the length of a term is important from my perspective representing the landlord.
Well, Howard, let me break in there because, maybe I'm disagreeing a little bit because generally in a...
That's your job.
Okay, tell my wife. Generally what happens in an office environment is businesses don't morph as much as what Peter gave a perfect example of the coffee shop. Peter, I know you broke up a little, so kind of fill in a little bit what you were saying, that, the Starbucks of today is not the coffee shop it was, 5 years ago or 10 years ago. But office generally does not change that much. If you're a law firm, you're not going to be an accounting firm in 5 years. You're not going to be a call center in 10 years. So that's why I say office is much different and we get more broad. But when you get to retail, now you got a horse of a different color. And I think that's an important issue.
Yes, absolutely. So Peter, why don't we move into the type of property? Let's see if your Wi-Fi can stick with us here.
Yeah, certainly hope so. So as Jerry was pointing out, in office you can be a little bit more open, but within retail, what you want to describe in the use clause is what the tenant is going to be selling specifically. And the reason for that is that a good retail landlord wants to merchandise their property. So for an example, you don't necessarily want 3 coffee shops in a row or 3 sandwich stores. You want to have a variety. You also set up a type of competition where you won't get percentage rent shopping center. So it's very, very important. And the example that I use is the company Whole Foods. Because Whole Foods isn't a grocery store anymore. Whole Foods is a department store because they're Amazon, and they're now a pickup point for Amazon products that you buy online. To have in retail a very defined.
Let me switch a little bit here. Peter, I am going to execute you unless you get an Ethernet cable, which you can get 100 feet and run it from your home router all the ways to your office and then roll it up when we're done. That most likely is the problem. So yeah, retail from the landlord's perspective, you want to be more restrictive than you might be in office because the tenant mix is much more important generally than it is in office. Industrial is, to me, is kind of a hybrid because you've got a whole bunch of other issues with industrial, which includes egress and ingress, rail lines, a whole bunch of other things that can affect industrial use, including the availability of power, which is usually not an issue in office or retail.
And
Peter,
don't forget things like hazardous waste and environmental concerns as well.
That was the thing I was going to mention. Yep, Peter, thank you. Yeah, that's probably the biggest issue. I mean, I was with, for example, today I was with a food company, a food distributor, and all they do is bring in the boxes. They're already packaged. They bring them in on pallets. They take the forklift. They take from the pallets. They put them on the truck, and it goes out. So, of course, the broker who we met with, their first question was, are you producing the product? Are you bringing in raw material and packaging it there and then delivering? So what is your process? So that was another question. So that's where we get into if you want to say a use clause, where we might be as expansive as possible, and say other legal use, but we want to make sure that even in the lease, we will say what we are doing right now. And then somewhere maybe in an addendum, it might be a little bit more specific because the addendum could kind of change a little bit. You could modify that a little bit down the road if necessary. If you do have to start actually packaging the product, you might add an addendum that, okay, moving forward, we're going to do the same use except, and then the landlord has to, agree or not agree. But industrials, that's a tricky one. That's a tricky one. What do you see from the landlord, from Peter, from your side?
The other thing with that, Jerry, is that you don't want to have a tenant that creates a nuisance by sound,
noise,
odor, all kinds of other things. And so that's why in industrial and warehousing, you need to know what's going on. Because it could also, using your example of the food production, the first thing that came to my mind is, man, I'm going to really want to bump up my pest control clause in the lease and my nuisance clauses in the lease. I do a lot of work on the tenant side with Anytime Fitness. And one of the things that they have within the use clause, it's aligned with another clause in the lease, is relative to the amount of noise that's being made because they're open 24/7. Well, if you're in a mixed use development, you don't want to be in a position whereby your tenants, your residential tenants above are complaining because they have someone dropping weights at 2 o'clock in the morning. So it's very important to understand the use clause isn't a standalone clause. It impacts so many other parts of the lease.
Let me give you a crazy example. You talk about rodents or whatever. I had a bakery, and the problem with them is when they would put out the trucks would come in with the flour, the seagulls would come in from the ocean, they would feast on the flour. So we had a real problem. The neighbors were going crazy, and there was nothing in the use clause. We were a bakery. That's what it said. That was our use. So we worked with the landlord, and in fact, this is kind of a weird story. I asked a friend of mine who dealt with a large bakery back in New York. We're in California, and we said, "What do you do to relieve this?" And they said, "Well, we put down Clorox." They would put down Clorox. It wasn't poison, but it tasted god awful. And the seagulls would come in, they'd eat the Clorox, and they'd go, "Ooh, poo," and they'd leave. But our lease clause permitted that use. So next time, landlord thinks a little different.
Yeah. Now, Peter raised something important. Is the use clause is not so much a standalone provision. So when I talk about the use clause, there's also a provision that often is contained within the use clause, which is prohibited uses.
Yeah, well, that's a good point.
Yeah, and the prohibited uses is when you act as either public or private nuisance. You disturb any of the neighboring premises, which sometimes is a little bit difficult to define. But if you've got seagulls pooping all over the sidewalk, well, that's very important. That becomes a health hazard. And then there's all kinds of language in those prohibited uses. I probably will publish a copy of the prohibited use provision that's in the office lease. I find not as much problems in office leases as I find in retail, because you have all kinds of issues with restaurants in terms of smell, in terms of grease traps, all kinds of issues that often will cause problems. I've had it where the restaurant was uphill from all of the other restaurants, and they didn't clean out their own grease trap. There was a communal grease trap that got plugged up, and all of the retail spaces downhill got flooded because it all backed up. So, I mean, these are the kind of things that you have to pay attention to. I want to add that also where you find a particular problem, and Peter, you could probably join in on this, is on multi-use properties where you have retail below office or retail below residential. And that becomes a problem also, because if it's residential, then people don't want to smell what's ever down below. which you can take any number of ways.
Yeah, and that's where you have to be very careful in a mixed-use development. And actually, you will find some prohibitions on things that you would commonly expect to be there, such as a coffee shop. I keep going back to the coffee shop, but the problem with the coffee shop is that if they do on-site roasting, that needs to be vented. And I know of a situation whereby there was a coffee operator that did roasting on site and they vented. Unfortunately, due to their location, they vented right into the air intake for all of the residential component of the building. So people weren't sleeping at night because they were hopped up on caffeine fumes. So that created a problem. And it was just, a lot of things came into play there, which was, I don't think the landlord knew that they were going to be roasting on site. The plans weren't reviewed properly relative to everything else. So a whole bunch of things failed there that needed to be picked up. And again, in part, this goes back to the interplay of the use clause with other aspects. Howard, you talked about some of the nuisances that are within or the prohibitions that you have within the lease. And that's where you come in with, look, for an example, in this one, you might have a coffee shop, but prohibit them from roasting.
Well, Howard, one of the things with that use clause from a landlord perspective and from a tenant standpoint, I know this isn't a topic of discussion of this lease clause, but there's a thing called quiet enjoyment, which is a really critical lease clause, which gets into that type of thing. Exactly what you're talking about, Peter. You can have a tenant next door who's roasting, beans or whatever, and it's affecting all the residential people. I'll give you I've seen crazy examples like the guy at 3 o'clock who wants to pop popcorn because it's his afternoon snack, and the guy next to him, because it goes up into the plenum, it all comes down into his suite, and the guy was allergic to popcorn. So what rights does the tenant have? So even though the use clause said it was okay to be an attorney, but it didn't say anything about popping popcorn, because that was just common use of the day-to-day activity. So we had to really massage that clause to say that, hey, if we got a problem as a tenant, Mr. Landlord, you have to take care of it. Because most leases, in fact, there's a large company down here, I won't mention, but a very, very large landlord here in Irvine, that they had in their clause that if the other guy did something, that was your problem, not ours. So we worked diligently with their attorney and actually came up with language that is now part of their lease, that they accept the fact that, hey, if you complain and our attorney says, yeah, I understand what the problem was, then the landlord has to go in and fix it. So you have use clause, but it might be something that's not really even covered under the use clause. That's where quiet enjoyment comes in. So we got the two that are married in some way.
Well, being the attorney here, I should probably jump in on the quiet enjoyment thing. Quiet enjoyment means more than just a place needs to be quiet.
Yeah, right.
Yeah, quiet enjoyment means that that the tenant is entitled to use the premises as they legally intended to do.
Yeah. Mm-hmm.
And that's really what it means. One of the issues that you were touching on this was, if a tenant next to you is using the premises in a loud fashion, and that's ALLOWED, not ALOUD.
I got one of both of them.
Right. As we all do. If they're smoking cigarettes or cigars, and the smoke comes over, that could be interfering your quiet use and enjoyment of the premises. And I've had a number of situations where that has happened.
Well, let me give you one we're working on right now. I've got a nonprofit organization that moved in. We relocated them to a smaller suite. And 3-4 days after they moved in, every time they flushed the toilet next door, you heard it. And the landlord came in and they tried to, put Instaquil up above the plenum. They tried all sorts of things. And they finally just turned to us and said, well, it's your problem because we did what we could and you could do it at your cost. And I said, no. So the use was, they had a big room that they had their meetings in. They were using it the way it's supposed to be used. There was no restriction. And here's the neighbor next door was the bathroom or the restroom. It wasn't, another tenant. So you never know. You got to be, that's a clause you got to watch out for.
Well, I'm curious. Was it the noise before it was flushed, or?
Let's just say it was all encompassing.
Yeah. Okay, guys, let's move on to prohibited use provisions.
Sure.
And I'm going to share the PowerPoint for this.
Mm-hmm.
So I listed these from this office, downtown Los Angeles office lease. And these are, of course, it was more like a page long, but I just kind of highlighted those things that they were saying that you couldn't have in the premises. Governmental agencies, that included both foreign, U.S., state, city, whatever. Peter, why would a landlord, now I know the answer, so but I'm asking you anyhow. Why would a landlord want to restrict the premises being used as a governmental agency?
Protesters and lawsuits, and people that are upset with family services because their child was taken away, and they come in with a gun and start shooting. All those things are reasons why you would not want a governmental agency. Also, the other thing with the governmental agency is they will say in their use clause, we will use it for any branch of the government we so desire. Well, you may not want the passport office on the second floor of a 20-story building that your tenants can't get up to the 3rd through 20th floor.
Mm-hmm. Yeah.
So that's very, very important. All kinds of reasons why you don't want to have a governmental agency there. Just a quick aside, when I was working for a landlord, I had 2 tenants for an office building that both wanted to be in the same office building on the same floor. We decided we were only going to take one of them. Those 2 were the consulates for Iraq and Iran. This was at a time when it was not a good time between those 2 countries. So yeah, you got to be careful.
The other thing too with the government agencies, a lot of government contracts will say that they could terminate almost at any time and for any reason. Their funding is pulled or something like that. So that's another reason why a government agency. The other one is the people in there. I hate to, I don't know if this is coming across unpolitically correct, but for example, it might be like you mentioned about a mental health agency. You have a building that's a 30-story, 20-story building with mostly professionals, lawyers, accountants, et cetera. And then you have 2 floors, the government agency comes in and it's got a social service type of agency. People going up and down the elevator are a little bit different. And again, I apologize, it's not politically correct, but that's the mix of the tenant. And that's where I think you have, Peter, don't you have here, Howard, on one of the lists is the reputation of the property of the landlord.
Yes.
That's the kind of thing if they, hey, that's a building that takes government agencies, you don't want to go in there. Government agencies, I had this happen with an accounting firm. The building put in over by Anaheim Stadium, which you're familiar with when you lived here in Orange County. They had, the County of Orange took 2 floors. They had to build a parking structure for the agency because they had so many people coming in, which impacted all the tenants in the building. So that's a real, government agencies, you see that all the time, Howard.
Well, I'd like to add now where I've got a considerable amount of experience. I used to be general counsel for a vocational school chain. Mm-hmm. And I will give you an example. Sometimes you just don't want students hanging out in a Class A mm-hmm. office building. We signed a lease for, I don't know, 40,000 square feet in a Class A building in Greenway Plaza in about 1986.
Well, Howard, you were 3 when you did that lease.
Yeah, wouldn't that have been nice? 300 might have been more like it. So we did this lease, and they paid, and it was interesting because that was during a gas recession.
Mm-hmm.
And the Greenway Plaza is in Houston. So they were desperate. It was a brand new building. They were desperate to get tenants in. So they structured the deal where instead of giving us free rent, they gave us $1 million. They constructed the premises for us, and then we paid rent right away. And the theory being for them is if they have tenants paying rent right away, then they'll be able to sell the building or refinance it. But the economy, particularly in Houston, was so bad in the mid to late 80s that they lost the property, or it was sold. I think they lost the property. We were in there 6 months, paying rent for 6 months, had $1 million in our pocket, which helped seed the development of other locations throughout the United States. And the new landlord comes to us and says, we would like you out. We don't want you as a tenant in the premises. We were like on the 8th floor. And I didn't blame him. You know, seriously, I would have never put a vocational school in there where we trained people to be nurses and security guards and whatever. And so they ended up paying us $500,000 to get out of the lease. You don't want, and in this lease provision that I looked at for this webinar, it did point out that schools or training facilities that are not pertinent to the actual operation of the business. Meaning, if you were an insurance company and you had a training room, you could do that, which I thought was reasonable. But I think that in terms of offices, that's another good restriction. You also...
There was one other thing I wanted to mention about vocational schools. I had a client, they had a vocational school. Actually, it wasn't a vocational school. It was an ESL school, English as a second language. And they had dozens and dozens of students come through, morning, noon, and night, because they also had extended hours as compared to a regular office. And it caused all kinds of problems, not the least of which, and this is why we were called in, they had their students would go out and would be in the hallways and in the lobby smoking and being quite loud, and it was disrupting, as Jerry was mentioning before, the other tenants in the property. There is another reason, and they say schools generally. I've seen now where some places have gotten fairly creative with putting in public schools, the government-funded schools, and you don't want the liability of a grade 2 or grade 3 student running away. Right. So yeah, I can see why you don't want to have those kinds of facilities.
Well, you know, we had a restrictive clause with one client. They were in a off of Jamboree here in Irvine. It was a school, like I think it was an English second language school, as you mentioned. But what I worked with the landlord. We knew they were coming in because we were renegotiating a renewal. So we wanted to make sure we heard about this. So we put in their clause, we had the landlord put in their clause that they were restricted actually to a certain portion of the building. So they had to park in a certain area. They could only come in a certain area. So here's another use clause, if you want to call it, with a restriction on this school. So Kline was in there for probably we did a 3-year renewal, never had an issue, but because we caught it ahead of time and we restricted them to that type of, if you want to call it use, another way to restrict.
That's so true. So let's talk about, here's one that I don't understand. Communication firms, such as radio and television. So if I signed a lease in an office in this building, because I operate online with CRE radio and TV, they could actually restrict me from being in there. That doesn't make a lot of sense to me.
It does make sense to me.
Of course it
does.
And I don't mean to restrict Howard Kline. I mean, as far as broadcasters are concerned. So there's a couple of things that one needs to be aware of. that is, a lot of broadcasters use microwave communication systems. And you don't want to necessarily have those bouncing around in your office. I mean, it might be totally harmless. I'm not making a health judgment here or jumping on are microwaves good, bad, or indifferent. But what the thing is, you've got other people in the building that might be concerned about that. That's item number one. Item number two is, again, I go back to the potential liability of people, taking pot shots at celebrities or perceived celebrities, or you have guests. If it's a news station, you could imagine having the President of the United States come into your office building, and what a disruption that would be to the rest of the tenants in the property, just because they want to have a sit down on a TV station.
Yeah, you just mentioned about the microwave. This morning, I was with a guy who, that's his business, is to put the cell towers into buildings. And he was talking about the new 5G and some of the restrictions that could occur, or health issues that they're thinking or could occur. So that's something I never thought of. I appreciate hearing that, because he just said this morning, timing was perfect on that.
The other reason that they may be restricted is, again, to utilities. Broadcasting facilities use a bunch of juice, and you don't want to necessarily have that as a particular problem.
Okay. So from my perspective, instead of saying no radio or television, if you're concerned about microwave, you specifically exclude use of microwaves and other things that in any other way might be harmful. The hazardous use clause could probably come into play when it comes to that. I mean, there is just, what it is this landlord probably paid tens, if not hundreds of thousands of dollars for a big law firm to create an outrageous lease. And this is what they came up with.
Dare I ask, Howard, how many pages this lease is?
60
pages, no longer an outrageous number.
No, we see all the time.
Yeah, the 60 pages. I mean, there was a time where 30 pages was considered a pretty big lease, unless you were in New York, in which case the normal was 90 pages. Well, what I used to explain to people was that in New York, the landlord, in the first 2 pages, the landlord states what he gives to you. And in the remaining 88 pages, he's taking it all away.
That's a standard lease.
That's a
standard lease, Howard.
Yet, and I love telling the story. When my first lease that I negotiated in New Orleans, the lease was only 4 pages long. It basically said, you're going to pay me, and that's it.
Yeah, well, Howard, we're all of an age on the panel here that the first lease I ever did was a stone tablet. But getting back to use clauses, we talked about microwaves, and you also brought up on your PowerPoint health professionals, and that is, again, for something else: X-rays and bio-waste and things like that. So and then also pandemic. There is a possibility that someone walks in and they have COVID-19. So that's why those people are restricted in some instances. I think, what this lawyer did is he just threw common sense out the door, or said, the leasing people have no common sense and can't be given direction by the landlord as to who not to have in the property.
Well, that's a typical attitude by attorneys, is that, now I'm both a broker and an attorney. So as a broker, I'm going, just let me do this. And as attorney, I go, I'm listening to the owner, the landlord, and I'm just depending upon the broker that I'm working with. See, if I was working with you or I was working with Jerry, then I'm pretty comfortable. But a lot of times you're not working with someone who's very experienced.
Yeah, but I kind of take back what I just said, because remember right off the top of the show, Jerry's going on the use clause on an office or any other legal use. So what this does is it says, okay, you're going to assign it from an accounting firm to a doctor's office. No, you can't do that. Yeah. And that's why that's in there. I mean, it's not the initial leasing. Let me
interject there, because what we sometimes put in there as comma as acceptable to the landlord, or so, as reasonably acceptable to the landlord. So Peter, that kind of takes that off the table. But Howard, one thing I'm hearing here is that this is one lease clause, but we talked about quiet enjoyment, but let's go to the rules and regulations, because oftentimes the rules and regulations will dictate some of the uses. For example, I think we mentioned it earlier about having a facility that has a lot of cubes and you're using a lot more electricity. So there may be something in the rules and regulations, not the use clause, but rules and regulations that says you can't do anything that is, will put strain, I'm using the words, strain on the utilities, or will use more utilities. So then in the utilities clause, there might be something that says, if you use more utilities, the landlord has the right to charge you. Or put in a meter. So there's a lot of these clauses.
Or if you're open 24 hours a day, 7 days a week, or you're open till 9 p.m. and the building shuts down at 5. I think if
Peter, could you just give me a break here and allow me to put on the PowerPoint, because we're really actually into the next slide, which is the related provisions. So just bear with me a second while I switch. Now, Peter, go ahead, start talking.
Well, there we go.
What I was going to say is that, too many people just look at the use clause, and because it's a relatively short clause, they don't pay any attention to it.
Right.
I think they really should. And this is why, I said earlier, it's not a standalone clause. It hits all of these other things: insurance, hazardous materials, the rules and regs, options, assignments, subletting. There's all kinds of different aspects. We have to bear in mind that the use clause is an integral and very important clause and should be drafted with care, whether you're working on the tenant side, the occupier side, or the landlord side.
Jerry, why don't you talk briefly about how the use clause affects assignment and subleasing? Because this is one of the most relevant provisions as it relates to the use clause that at least in my experience, is all of a sudden someone goes to the landlord and says, I want to assign or sublease this. And the landlord goes,
Right. Well, that's what I saw this particularly back in the early 90s when a lot of the buildings were going bankrupt and we had the recession where people had to get out of leases. And what they did was, we lost the PowerPoint. They were trying to get out of their lease, and they would try to lease it to another type of company that wasn't, again, a law firm leasing it to something else, but maybe it was an accounting firm. And the guy who was next door was also an accounting firm. And they went running to the landlord and said, hey, you can't do that. Well, the landlord, I've seen landlords use the restrictive use clause to deny the ability to sublease. Now in California, I believe, and Howard, you can help a little bit, you're the lawyer in the group here, the landlord can't unreasonably restrict a tenant from subleasing.
Actually, that's not true. Actually,
no? Okay.
the landlord can put in a provision that allows the landlord to restrict giving its consent under any circumstances. However, there are ramifications of having that provision in there, which can severely restrict the landlord's right to get future rents. So if you want to just say you have to get my consent, which can be unreasonably withheld, or I can withhold it in my complete discretion. You can do that. That law changed 10, 15 years ago.
Okay.
So, yeah.
Yeah, that's a lease clause that we do look at, very carefully, because, another thing too that's interesting is because a lot of companies are shrinking down now, if you want to call it that, they have single offices, 3, 4, 5 offices that they want to rent out. And it may not be an affiliate company, but it may be a related company, or it might be an accounting firm wanting to lease out to 5 attorneys. And the landlord could restrict that. So because, say, you're an accounting firm, you can't, rent it out to attorneys. So there's a lot of little idiosyncrasies here.
Yeah, and on assignments and subletting in retail properties, again, the landlord wants to know the merchandising, so you can't necessarily switch. But there's another reason as well. You know, you've negotiated for, I'll pick on the coffee shop again. You've negotiated for a coffee shop. There's a certain rent structure that a coffee shop can afford. If they could sell the lease at this point, because that's all that they would be doing if the use changes, to a jewelry store, well, there's a completely different rental dynamic that comes into play. And so the landlord wants to protect themselves.
Maybe you might want to explain what the percentage lease is to some people as a use.
Sure. So
Yeah,
very briefly, percent rent, and I'm just thinking base rent as well, Jerry, but also percent rent is a concept whereby the landlord in a well-positioned shopping center, let's put it that way, will obtain a certain percentage of a tenant's sales after a threshold, not from $1. And it's an incentive for the landlord to continue to merchandise the property properly, to drive more foot traffic, which in theory drives more sales and makes the shopping center more popular. So, and the percentage rent factor, which is what we call it, the amount of percentage rent that would be paid is different for a coffee shop than it is for a jewelry store or a gift store or a fashion store, because the gross margins are all different. That's another show's topic right there. But the point being is a landlord also just doesn't want to be in that position whereby not only have they lost merchandising control, but they also have lost the opportunity to maximize the rent on their property.
Good point. Yeah.
Let's talk, Peter, why don't you talk a little bit about exclusivity and exclusions?
Sure. You know, again, in retail, it goes to merchandising properly, making sure that, you know what you have in your shopping center. You have a good mix of merchandise that attracts the most number of people, that the sales are being allocated properly, particularly if you have percentage rent. And in office, we're seeing more and more that office tenants want an exclusivity clause. That exclusivity clause means you're not going to have a direct competitor, or you're going to limit the number of competitors or a particular use within the property. For an example, in a medical office building, you may say there will only be 5 dentist practices in the building and no more. And you could also, as far as exclusions go, this is what we talked about a little bit earlier, exclusions of certain types of businesses that you think would hurt your business. So if I had a church in an office building, I wouldn't necessarily want an adult store in the same building, or a cannabis operation, cannabis retail operation. So those are the exclusions that you'd want to have in there. Those have to be crafted very, very carefully. And so for an example, and it goes back to how you craft, and I'll talk retail, how you craft the use clause. For my use clauses that I craft from a landlord's perspective, they're very restrictive, and I have their primary use, what they do primarily, what they're known for, and then ancillary uses. And ancillary use, I also limit, what constitutes ancillary, but the ancillary uses complement the primary use. On the exclusion, I will give them, on the exclusivity clause or the restrictive covenant clause, protection on their primary use, but not necessarily on their ancillary use. Here's a great example. You have a burger joint. Their primary use is to sell hamburgers. Their ancillary use will be to sell pop and chips. Okay, well, if I have another restaurant that comes in, let's say it's a fish and chip shop, well, they're not going to sell burgers, but they should be able to sell the chips and pop.
Well, it's interesting. The only time I've ever had, trying to think in 30 plus years, a use clause restriction for an industry was back in the 90s. I had a, what do you call it? One of these firms where when you get fired, you go to, and it's kind of like a personnel firm, but they help you get another job. And he wanted to restrict that he was the only one on the floor who could do that, because he was concerned that, there would be other companies and people might go to the wrong firm. But I've been in buildings nowadays that there could be 5 law firms. I mean, there are buildings that are known as the law firm building, if you want to call it that. So typically, again, going back to office, we don't find those kind of restrictions by industry. It's more by, the type of use, like we said with that last slide about government agencies, et cetera, medical, et cetera, et cetera. So use clauses or restrictions on that part, not necessarily typical of office.
Yeah, exclusive provisions, starting getting a little dark in here, and then we're almost done, so I don't have the opportunity to turn on the light. I hope you can see me.
Oh yeah, you're
Okay.
still looking fine.
Okay. So the exclusivity provisions are predominantly in retail real estate. And I would tell you that in negotiating many of them, it's a fine line between not having enough detail and having too much detail.
Yeah.
And sometimes you don't find out that you put in too much detail until after there's a problem.
Yeah.
I would also tell you that in representing the landlord, I don't generally like to give any tenant an exclusivity provision unless they have substantial leverage.
Mm-hmm.
Yeah.
So an Apple store is going to have substantial leverage, but this is the kind of thing that relates to the use. It's directly related to the use. It's like, well, you can use it for anything you want to, but this. Now, when I say an exclusivity provision, that's more of a, when I say you can use it for anything but this, that falls more into the prohibited uses. Yeah. And then when you say exclusivity, you're actually granting the tenant the exclusive right to do certain things in the building or the shopping center or the project. And that becomes another thing. And where the landlord starts willy-nilly handing out exclusivities, they start running into a problem having the property managers and the leasing people adequately paying attention, because it takes work unless someone puts it together in a spreadsheet of sort. So you go, or do we have any exclusivity provisions here? And what does it say? Can we bring the tenant in? And I have been involved in lawsuits where the landlord and the property managers didn't have a solid system to pay attention to it.
And we need to have a show on exclusivity clauses, because they have to be worded very, very carefully. For an example, I ran into a situation once where the lease clause said you can't have the landlord wouldn't permit another tenant to do something, whatever that something was. Mm-hmm. Well, the landlord then became the referee, and the landlord's job really only is one job, is to lease space. So if I had to give away an exclusivity clause, and I agree with Howard, from the landlord's perspective, you never want to do that. But if you have to do that, it just limit it to what the landlord's function is, which is leasing, rather than being on the hook for some rogue tenant going off and doing their own thing. And I'll give you a prime example of that and why exclusivity clauses are dangerous from the landlord's perspective. Tim Hortons, well known throughout all of Canada and is now branching out fairly successfully in the United States. It is Canada's better version of Dunkin' Donuts. And it's a coffee and donut store. And
my favorite.
Okay. Well, wait till you get to Tim Hortons. It's basically a coffee and donut store, and they had some breakfast things. Well, the parent company, which is a multi-brand European company, said, well, let's experiment with our menu for a little bit here. And all of a sudden, they started selling hamburgers, Beyond Meat hamburgers. Well, you don't have in your wildest dreams that in the shopping center where you have a Burger King or an A&W or a McDonald's or a Dairy Queen, that Tim Hortons, known for coffee and donuts, is going to be selling vegetarian hamburgers. And there was a huge uproar with tenants in the burger sandwich category when Tim Hortons started doing that. lasted all of about 3 months before all kinds of legal letters started flowing across the world.
Now, I wouldn't all be surprised if somewhere, it's getting pretty dark now, so, and we're wrapping this up, but wouldn't all be surprised that there's some exclusive or prohibition on selling hamburgers? You know, and
there were. These tenants said, no, we're the only hamburger operation. And all of a sudden, these guys started selling hamburgers.
Well, no, they're selling Beyond Meat. Are those hamburgers?
They call themselves hamburgers.
Yeah, and I tell you that 10 years ago, there probably wasn't an attorney who contemplated Beyond Burgers or the Impossible Burger.
Yeah.
Gentlemen, Jerry.
Yes.
And when I said gentlemen, I was referring to you too. Okay, so I'm sorry. That's part of my panache here. I am going to switch to the. I'm going to make the PowerPoint available separately from this, since we did a lot of video presentation, but I wanted to let everybody know that if they wanted to know more about CRE Radio and TV, you can go to creradio.com. I will also shortly be having my law office website up because I am going back to doing what I do best, which is negotiating leases.
Awesome.
Yeah. And
there you go.
Yeah, so the Greenstad Group, that is Peter's company, the Greenstad Consulting Group, and you can find them at Greenstad, that's TEAD, CG.com. And Jerry, you can go to http www.inhousecorp.com/in-house-testimonials.
Yeah, we could probably leave off the in-house testimony, just inhousecorp.com. That's the homepage.
Well, you should have corrected me when I let you see this first.
That's right. I like to hear what people say.
Yeah. So probably at this point in time, nobody can see me, which is probably a good thing. So in my view right now, Jerry's on top, I'm in the middle, and well, Peter, you're at the bottom again. Yeah, can I move you? No, I can't move you. So guys, really good conversation. I really enjoyed this. This will be available by this weekend for everybody, so promote it. And both Peter and Jerry, you can refer business to me.
Yeah, legal business. We can start doing that.
I want legal business, so come on. And no more litigation.
Okay.
I'm tired of beating people up in court. So guys, you have a great day. Thank you very much. And we'll see you in a couple of weeks.
Sounds really good.
Thank you very much. It was a pleasure. Thanks, Peter. Take care.
Bye.
Bye now.
Bye-bye.